Please wait. These are 2019 matters. Unless we look at the file, we are not adjourning. Please wait. Renew the prayer when the matter is called. Yes. Renew the prayer when the matter is called. This is motion matter. Okay, let the matter be called. We'll pass orders. Because unless we see the records, we can't pass an order. Ask somebody to be here. We'll just see and pass orders. We have marked it. You just let somebody be here. Hmm? Okay. Okay. Item 21. So both sides are represented on the prayer made by learned counsel for the year for the petitioner. The matter stands adjourned today. The date after 4 weeks is okay. Yes. '28. '29. Both sides are represented. Pass separate orders on the here that the learned counsel for the petitioner holding the brief. Could not attend the court today due to medical reasons. The matter stands adjourned today. You want after vacation? Give a date after vacation.
27th April.
May I please, Your Lordship? I beg to mention item number 23. A senior counsel can't appear as for medical reasons, and kindly list the matter after 4 weeks.
Same.
27.
May I please, Lordship, I beg to mention item number 7. Due to his father death, he is not able to attend this court.
7 is 2019. Please wait. We understand he is on payment, but still it's 2019 matter. Please be here. We'll adjourn it, but after looking at the record.
Okay, Lordship. Deeply obliged.
Item number 2019 matter. No, please wait. Unless it is called, we are not adjourning. Unless we look at the record, we are not adjourning 2019 matter.
Supply item 38 for delivery of orders.
Mr. Sharma. This was found to be one of the most inept, clumsy, and casual drafting of the writ petition. And therefore, we are dismissing it with liberty to the petitioner to post again. This is one of the most horrible drafting I have come across. That day we deliberated for more than an hour. We expressed our mind that we'll be allowing the repetition. We drafted the order. You'll be surprised to know 37-page order was drafted to allow the repetition. And ultimately, we had to dismiss it.
Right.
Most inept drafting.
It is listed minus perhaps item 8 today.
Huh?
Bikul Vara, that matter. Today list, it is listed item 8. Bikul Vara matter.
Criminal case.
Wrongly listed. Wrong, there is.
Same case, this one.
Same case.
Same case.
Daily list item 1 for motion.
Mhm.
My lord, you have challenged the order, but this is S50.
Lordship, Mr. Sharma would be doing this matter. He has said
Just wait for some time.
records are with us, Lordship.
Ah, yes, you understand.
He will be coming.
Just wait for some time. They have to address us on the documents.
Yes, Lordship.
Why don't I have other matters?
Can do.
Item 2.
Yes. Pardon me? Both sides are represented on the prayer made by learned counsel for the petitioner. The matter stands adjourned today. List again on. So we'll, since we're adjourning, we'll keep it in the admission column. We issue a notice and it is in the admission column. So that person to order past a day, the records of the tribunal is received. Accordingly, the court is inclined to issue an offer of motion returnable forthwith without requiring any interest taken. Next, list in the admission column on date after. Give it after the
27. Item 3.
yes. Can you please come to page 2 of the writ petition? What is the name of the petitioner? So it is against Hashim Khan. It is against Hashim Khan. So your name is also Hashim Khan. You have admitted here in page 3 or cause title. Yes. Mistake. Everywhere it is Hashim Khan. Send it back. Purpose determinate. Third, says Ahmed when asked for the petitioner and so for the respondents. By filing this writ petition under Article 226 of the Constitution of India, or the petitioner, namely so and so, has assailed the opinion dated page 92. Dated 23/5/2019, passed by so and so, thereby declaring the proceeding Ahasem, Ahashem, Ahasem Ali, son of Kudus, Kuddush, of village Tatikuchi, Tatikuchi, PS Corpeta, district Corpeta, to be a foreigner of post 25 to 1971 SP. Next. The learned counsel for the petitioner has been able to demonstrate that the reference was against Hashem, Hashem, Hashem Khan. And that the electoral registration officer of 47 Chenga CAGNGA, Chenga Assembly Constituency, ordered an inquiry by memo number 2/47/680 dated 11/11/1997 in respect of Hashem, Hashem Khan, son of Kuddush, Kuddush. Accordingly, the superintendent of police, the packet order, packet to Corpeta, in its form of reference, had submitted the reference in respect of Hashem, Ashem, Hashem Khan. However, in the letter of reference bearing case number
The next statement.
7232 of the 98 dated 26/1998. The Superintendent of Police Order of Kolkata forwarded to the illegal migrants within bracket determination tribunal at Kolkata, the doubtful case number 7232 of the 98 against Hashem AHASHEM Hashem Ali, along with annexure A, annexure B, and form number 7. Resultantly, the reference was registered against Hashem Adi, AHASHEM Adi. And the said proceeding was declared to be a foreigner. In the said context, it is noticed that the present petitioner, Hashem, HASEM, Hashem Khan, alias
It is the next statement.
Hashem, ASHEM, Hashem Khan, alias Hosem, HOSEM Khan, that stated in paragraph 1 of the written statement that in the notice of the tribunal, his name is wrongly, his name has wrongly appeared as Hashem, ASHEM Khan, instead of his correct name, Hashem, HASEM, Hashem Khan. And in his evidence on affidavit, has been reiterated in paragraph 14 that his name, that in the notice his name wrongly appeared as Hashem, ASHEM, Hashem Khan. Be that as it may, in the Reference records the name of the proceeding is Hashem, Hashem 3. Therefore, the petitioner, the run cost, the petitioner submits that this is a case of mistaken identity. Next. Although the learned standing counsel for the FT and border matters has supported the impugned opinion, but having noticed that the electoral registration officer, right, communication dated 11/11/1997, had doubted the citizenship of Hashem, Hashem, Hashem Khan. And it is only in the forwarding of the reference where the Superintendent of Police within bracket border, bracket Kolkata, has referred the name of the proceeding as Hashem Ali, Hashem Ali, in doubtful case number 7232 of 1998. The change of name from Hashem Khan to Hashem Ali has happened. It is, we also take notice of the fact that as per the first order in the order sheet of the Foreigners Tribunal -1, Kolkata, or the name of the proceeding is mentioned as Hashem, Hashem Khan. The first order dated 24/4/2018. Here, the opinion is rendered against Hashem Ali, Hashem. Next, therefore, court is of the considered opinion that the matter needs to be remanded back to the said learned tribunal to ascertain the name of the proceeding. And then before that, and moreover, the title page of the proceedings also contains the name of proceeding as Hashem Khan, Hashem Khan. So therefore, the court is of the considered opinion that the matter requires to be remanded back to the said learned tribunal for first determining the name of the proceeding, and in the event the name of the proceeding is determined and the present petitioner is the one who has desired to be proceeded against, the said learned tribunal pass a fresh decision in accordance with law. Next, facilitated the same, Court is inclined to set aside the opinion dated 23/5/2019 in respect of past by so and so incident in respect of ASM AHA ASM Ali. It will not be a bar for the said learned family to first determine the name of the proceeding and thereafter pass the French judgment in the event the present petitioner is the desired proceeding. Next. The proceeding who is duly represented by his learned counsel or is directed to appear before the learned member of Foreigners Tribunal 1, make it first, tribunal number first, one of the time. On 30 April, 2026, by producing the certified copy of the order, to wait for further orders to be set on the tribunal. Next one, it is made clear that if the petitioner fails to appear, the date fixed to be permissible for the said learned tribunal. If the petitioner is absent on court and passes the orders. Next. The registry shall send back the records, signature fee. Next. Along with the copy of this order, we made a part of the record by the said learned tribunal. The questions as allowed to be extended to the above. Demand of the matter.
Obligement.
Item 4.
My lord, in fact, it is the case belongs to my junior, Mr. Farooq. He met with an accident. That's why, my lord.
No.
Anyway, I'll submit it.
No. We wanted, without looking at the records of 2019-20 matters.
Yes, I'll submit one.
Lordship, notice has not been issued in this matter. Lordship may issue notice and fix up for admission hearing, Lordship. I just went through
Notice
the
has not
order.
issued?
No,
Oh, my.
LCR and interim is there.
Administrative Vishwas and not for the petitioner and transfer for the response. Next. Pursuant to the orders passed earlier.
Yes,
The record to the tribunal which requires examination. Accordingly, the court is inclined to issue the honorable court with regard to any interest taken. Next, this is the matter for hearing.
They don't accept that I am.
The week commencing 25/5/2026.
Item 6.
Lordship, item 5 also notice has not been issued. If Lordship would like to issue notice and. fix
Item 5.
admission both. 5 and 6 both, Lordship, no notices have been issued. Same order for 5 and 6.
Obliged.
Lordship. 6 is again, Mr. Biswas was there, na, his junior. F.A. Hassan, Lordship, he said he met with an accident.
Item 7.
Seven, this is a notice issue lottery. I don't know, notice some file issue also in my. I think 7 days. मेरी बोली से पहले पूछा। Lordship, it's not here. Maybe Mr. Sharma has it. Yes. Records में इधर के पास है. किसने लिया? हाँ. ये देखो.
Item 9.
तीन देखने से क्या है क्या?
Item 10.
9 time being lordship. 10. 10 और 10 से तो रखा है. Orders to display email में hard copy. वहाँ नहीं. बड़ा कुमार. या फिर ये तो काटी दिया से होटेल दा. ये काटी दिया से.
Then you don't find a connect between you and your parents.
Only, let it, my love, the school certificate and one.
That was not proved. The Gaupura certificate was not exhibited. You produced it but not exhibited.
Certificate is produced, but issuing authority not.
Pardon me?
The school certificate goes up exhibited, my lord, but issuing authority is not proved
Correct,
by calling.
correct.
Okay.
And even this was your Gaupura certificate was also not proved. It was just filed.
What is this all telling me? Hotel is even so kelly. Then I'm a hotel is nice. Hotel is nice. What are the dishes? Document and identify.
There was 177. 77 was.
Still I'm noting this. কি লিখিস?
Yes. Exhibit পদক্ষেপ 1 ভোটার তালিকায় 1965 Yes.
Notary.
Which is again clipping.
Sí. Yo puedo escuchar más.
Thank you. Correct.
Make a petitioner looking power with it.
Maybe Miller, petitioner asked the notary to put these two exhibit Miller. That may be happening. Yes. And in paragraph 7 Miller, here is mentioned 1965 and 70 voters.
Status of the said reference has not been brought on record. Similarly, it has been stated that a reference was pending against his mother, Azira Khatun, Hazera, Azira Khatun, Khatun, before the same tribunal. So, however, the opinion in the reference has not been brought on record. Therefore, on a conjoint reading of Exhibit 1 and 2, the petitioners could not prove his link with his projected father or grandfather. First off, it is a settled law that only by production of the voters list, it cannot be proved that the person whose name appears in the voters list is the father of the petitioner or father or grandfather of the petitioner, which must be proved by any other cogent and admissible evidence, documentary evidence. And then oral evidence is not sufficient to prove citizenship or connect or to link the witness to his projected parents. Next, already stated above, our school certificate with bracket Exhibit 3 has lost its credibility of having not been proved by the author. Next, no other documents were exhibited. Therefore, on an independent appreciation of the evidence on record, we arrive at the same conclusion as the tribunal did. Accordingly, don't find any infirmity or perversity in the appreciation of evidence, feelings and evidence by the tribunal. Next, resultantly, the you add there on that accordingly, no interference against the set of the opinion dated 25/7/2024 is called for. Accordingly, the consequences of the opinion dated 25/7/2024 passed as a case section that follow. Next, the jurisdiction send back the records. The Janet Tribunal, along with a copy of this order, to be made a part of record by the said Janet Tribunal for future reference. Artisan record bearing the loan cost.
Item 11.
The records have not come. You don't have the opinion. This is,
Not annexed.
you don't have, there's something wrong here. That's why you're searching for it, but records will not come. Can we come to page 22?
I'm at 22, Lordship.
Now, this is an application.
Lordship, all documents are not annexed to this petition.
That's okay, but this is an application under section 3A.
Yes, Lordship.
For an opinion which was passed on 24/2025.
Yes, Lordship. Some dates are not matching, Lordship. It says the petition is filed on 28/7/2025, more than 1 year back.
That's why.
Yes. And the opinion is.
Well, 1 month back, it should be 1 month, it is written 1 year.
1 year.
But
No, Lordship, why the ex parte opinion has not been annexed to this petition, Lordship? They must be having it. They. Informed that no such order was passed. Do you have that document? Huh? Verbal submission is, how to
no, but
rely
there's
on it,
no
Lordship.
statement in your writ petition for that.
Yes. That they applied and they were told that no order was passed. Record is easy. No, Lordship, we'll call for the records only when the opinion is that they have not annexed the opinion.
Maybe if she's right, we don't know.
Yes, Lordship.
We are not doubting her. Let us see the records.
So a reminder may be sent for the records, Lordship.
Had miss F interest and count for the petitioner and also for the respondents. Next paragraph. Although requisition for the records were sent by email.
Paragraph 12, Lordship says various ex parte orders were passed. Paragraph 12, Lordship, where statement is that it is pertinent to mention here that due to certain reason, various ex parte orders were passed against the petitioner by the tribunal, which were subsequently vacated. This does not make too much of sense, Lordship. No, the records would reveal everything, Lordship. the conduct or how the process in which the proceedings were taken up, Lordship.
What was sent on 10/3/2026. So however, the records are not yet received. So the registry shall send a fresh reminder, send a reminder, urgent reminder to the learned member from Foreigners Tribunal 7th, Sonitpur, Tejpur. Expeditiously send the records. Next, this order be brought to the notice of the AOJ FT section. Next, list on 6/4/2026, awaiting receipt of the tribunal's records. Mr. Sheikh, 6th. Balipara.
Yes, Lordship. Yes, please.
Then we have understood what has happened. Balipara, not Tejpur. Sonitpur, Balipara. Balipara. Okay.
Item 12.
Mr. Sheikh, it is good you are giving opportunity. It is good you are giving opportunity. Okay. Given adjournment, Sheikh, okay. He is out of his review. Okay. Both sides are represented. On the prayer made by Rana Council to the petitioner, the matter has been adjourned today. This immediate. The 6th of April.
Item 13 for delivery of orders.
The repetition is dismissed on merit as well as on the ground of delay and latches at the motion stage without issuing notice of the respondents.
Item 14 for delivery of orders.
This petition is dismissed at the motion stage on merit as well as on the ground of delay and laches.
Item 15.
Yes. Okay. And the
Item 16.
and
$17. 17 पन्नी 17 देना ना
17.
Lordship, for impute opinion in the page number 88.
which date is it opinion
26.
and all right
your name?
ZH Bora.
ZH Bora. ZH Bora and copy of the petitioner. And sponsor for the respondents. Opinion is at page 88,
all right
dated 30 January 2026.
1819 rating it's
State notice call for the records. Stock office within 2 days. Therefore, bail is opposed by the runs standing counsel for safety and bottom matters. 10 days time to take bail of which 5,000 to be satisfactory not applicable of this brother, Walpara.
yes what is it
Item. Item 18.
Mayor, please, Your Lordship. The matter will pass over for timely.
impugned opinion is of 2011-25 lordship
Page 80, madam.
25. Your name?
F. A. Ahmed.
F.A. Ahmed. Sponsor for the respondents. Page 80. Opinion dated 2011-2025. March by students, case number, inquiry number. Same order, 10 days time to take bail of rupees 5,000 for the satisfaction of dependent of police border, Golaghat. Stock office within 2 days.
Item 19.
Lordship, kindly pass over the matter for time being, Lordship.
impugned opinion is of 20 lordship it's 28-20
20 days. Okay, time being. Highly pressed. Miss,
happening now.
Ms. Verma, it is, the home after this election, so now we'll have to take urgent steps for training the staff and the member on record keeping.
Yes, Lord.
Yesterday, a lot of time was spent in our matter. And records are very, very inaptly kept.
Lordship, during, after Bihu, Lordship can fix up a date. We can communicate with the department, Lordship, after
In
Bihu
that case-
holidays.
In that case, it will be listed, I think, in a day or two. Where we'll give a direction,
Yes, Lordship,
mandatory direction to have it.
to arrange, we will do that, Lordship.
There are two documents, set of documents, which has two different documents, having two different documents inside, and all are marked with the same. exhibit
Same,
number.
okay.
Creates a difficulty when we examine the records.
Time being item 9.
Well, sure was on the earlier occasion also.
Yes,
So this is a case where a reference was initiated against the mother of the present petitioners. Inquiry reference as well as notice was served on mother of the petitioner. But tribunal declared the petitioners, present petitioner as well as their deceased father to be foreigner. The order page 80 is the order for initiation of inquiry. This Jorina Khatun was the suspected person against whom inquiry was directed. And 81 is the reference, page 81.
yes, Ms. Verma, put the day record, is correct. This book, it will take it up after some time. The reference is against that lady alone.
Lordship will take up this matter to Lordship.
Two.
Okay.
Lovely.
Item 9.
Time being item 15.
So Lordship, different for every place. So this is the thing that was. This petitioner has been declared as a foreigner of post 1971. Only Lordship, the only discrepancy regarding Lordship his father's name.
More material is the delay,
Delay Lordship,
2019,
yes, Lordship.
2026. There's a lot of
Lordship.
time.
I've given a statement Lordship in page number 13. Paragraph number 20 Lordship. Delay is Lordship, happened, this is delay of, it is a case of 19. However, Lordship, because of his financial hardship, as well as the proper knowledge about his
we adjourn the matter for today. We'll take it up after 2 weeks. Plus, this same thing which happened few days back.
Notice it, Lordship, and must have missed it.
See the file. You don't have to open it, just bring it closer to your, bring it closer. Bring it closer.
Yes, Lordship.
You're getting the perfume,
Yes.
correct? This we dislike.
Is there any fault on my part, Lordship?
Yes, look at the record, smell it. Smell it.
The perfume doesn't show. Better bulldog also.
Smell it, smell it.
Lordship, sir. Wait, Lordship, what is the smell this problem?
We don't know, but this we dislike.
So, Lordship, is
This
something
is-
is there.
This we don't know. This procedure is not there in the High Court rules, and therefore we adjourn it.
Lordship, what happened 2 weeks back? I'm not aware, Lordship.
You see, we took an exception of the habit of bringing up files in this bench, which is loaded with perfume. We've got nothing against it, but it distracts us.
Lord,
And once there is a distraction, we want to take it up. As simple as that. The just say, Mr. J. Kalitalan caused the question. And also for the respondents, next one. The court has been distracted with the perfume sprayed in the case records, in the file. So accordingly, the matter stands adjourned today. List on 20 April 2026.
And the smell is quite strong. After I sent back the file, I realized.
and it was filed long back, before 1 month probably, Lordship, but today even I have not touched the file in the morning
So
also.
for that, this is something which is distracting us.
Lordship, it's fine, Lordship, sir.
Lordship, it may be the room freshener which
Yeah,
they
yeah,
put
yeah.
every morning, Lordship.
Might be.
Because
Lordship.
every morning when I come quite early by 9:20.
Doesn't happen. We deal with so many records daily. Every day we
Maybe
don't react.
one of the lucky ones to get some fragrance, Lordship.
Got distracted. Nothing against it, but this is a practice we dislike. At least in the bench, I dislike.
Time being item 19.
Yes.
May I please, Your Lordship? In order, Your Lordship, is 102.
Yes. 2020.
2020.
What is your explanation?
Explanation page para, Your Lordship, 16, Your Lordship. 15 and 16. 16, Your Lordship. You must say 2 cases is run against the petitioner. Your Lordship, in the
Page
same
number?
tribunal.
Page number
Page number 12.
12.
Proceeding complete, sir.
There are 15 valid petitions.
Right. So as Islam doesn't counsel for the petitioner and so is before the respondent. Opinion dated 28/2/2020, page 102. Asked by so and so in case number so and so. Reference number so and so by which the person was declared to be a foreigner, postpaid in 1971. Notice returnable to form so and so. The date after 4 weeks. Returnable on so and so. For copies will do this, for the reports, following email address. Prayer for bail shall be considered on receipt of the tribunal's report. In the meantime, if the petitioner, namely so and so, is alias so and so is apprehended, he shall not be deported out of the country without order of the court. Next, the petitioner shall cause production of a separate copy of the order before the superintendent of police, Border Baksa, to bring the order to the notice of the said authority. Based on so and so. What has happened to the other, what you call proceeding? You have not stated anything anywhere.
No, Your Honor, I have filed another case. I have filed another case, Your Honor. This petition I have filed only but not tested.
Okay, but you should have given a statement here somewhere. That you have not given.
Then they, we have filed, I think on the date come there.
If there is a statement, the two proceedings were.
Yes, there are 15 I have.
There are 15.
No, but please, what is the opinion and what is
Opinion,
the?
same date, Your Honor. I have already filed. This is already
Did I ask him?
same date.
Time being item 16.
Wait, you know,
Yes,
in this case, what happened? The order, order is of 12/12/2012. And after that, the petitioner was deported on 26/12/2025. Now the petition has been filed by the daughter of the proceeding. So, my humble presence notice may be issued and record may be called for. There was an ex parte order and due to the Financial weakness of the petitioner, they could not file the appeal earlier, petition earlier.
Given a typed copy of the order? No, this is not legible upon. Lordship, I would pray for a fresh copy of the petitioner. We can't read the infused order, Lordship.
Copy.
Page 21, Lordship, I can only see some black lines, nothing else.
A better copy of this.
Yes, Lordship. It is same here, I also cannot read it. I have I shall make one copy of it. What do you do?
Uh,
Okay.
You've got a readable copy. You've given a readable copy, no.
Lordship, I have just found it from my record.
Okay. Then
I-
we take it
I
up day
can't
after
see-
tomorrow. We take it up on
Next week.
some other day. Let's just look at this.
Depending on
Because he appeared and never filed his WS Lordship. Certified copy obtained in 16 Lordship, but case filed in 26, 10 years after the certified copy was obtained. I cannot keep this copy.
what are they? No,
Can I
Pick up it.
you know, 16 locations number that we- नहीं, तो फिर legible है ना, बाकी document अपना legible ना है। ये demand documents notarized है, that are legible ना है।
এইটো টাইপ কৰি দিয়া গৈছে বাকীবিলাক ডকুমেণ্ট
ठीक है, photo खींच लो।
But then you are at default. The ex-parte, you appeared and did not file your return statement.
Yes, Lord.
Then we can't, after 14 years, we can't certify this.
And already deported also, Lordship. It's already been deported.
No, not deported.
Yes, yes.
He's facing expulsion order.
So,
You see, look at the prayer. The prayer is for stay. So once he's deported, this is effective. That can't be stayed. Expulsion order, page 19.
yes, sir.
There is to stay the expulsion order. One has been expelled, how can you stay? So we are presuming he's not.
But has he annexed the order, Lordship? Has he annexed the expulsion order?
Yeah, it's okay, you have an expulsion order, but you can't expel him. Otherwise, why would a person ask for stay?
In my prayer is not clear because I am, to my information, he has already been expelled.
Then why is this prayer? If you had the knowledge, then this prayer would not have been there.
So first he mentioned that he has been reported, now his daughter has filed it.
No, no, because you see, when we were reading, we did not observe that submission, because the prayer, we first saw the prayer, then the affidavit by the lady, then this is how we proceed, so. We just have a wrong way of reading.
You can get instructions whether he's been deported or not, Lordship. And then the 2012 order, we'll have to explain now. I think now to me.
Joseph, a person has been taken into custody for deportation, but that information whether he has been deported or within in the custody, that is not clear.
The petition also has been defined. Find out
But,
where-
but Ms. Verma, with something to ask you.
Yes, Lordship.
Please come to page 36.
36. Yes, Lordship.
You see, this could only have been issued by the foreigners tribunal. We are presuming that is an HFO, but you see, there's no date of issue, there's how the certificate copies were issued, we don't know.
My copy is showing NHA 3, Lordship, page 36.
36 is an HFO, according to us.
NHA 4, Lordship.
It was certain tickets already. So exhibit two times.
What are the exhibits? NHA 2 लिखा है मेरे
The second judge's copy, you don't mark it, it is NHS 3, exhibit 3, page 36.
Yes, Lordship.
Even if the second judge's copy, you have not marked the NHS. Even my sister had
No,
difficulty.
NHS, Lordship, I can't, my copy is completely not legible at all, Lordship, the last
No,
page.
we are not on that form. This is a certified copy,
Yes, Lordship.
but the date of issue is, we are not finding.
This might be because all those certificate copies was taken in advance. The first page that was mentioned, but subsequent pages that is not there.
It says Office of the Foreigners Tribunal, but no date, and there's a overlapping of documents, Lordship. It seems the stamp paper has been kept, and on top of that, this inquiry form was kept. Because the inquiry form would have been, there in the
Page
record.
36, there is some legitimate, but there's no signature, nothing. That's why we are asking.
Yes,
You'll have to flag this to the Home Department. If this is the manner in which they are issuing without authentication of the documents, very difficult.
Only seal of the forest tribunal is there. No signature.
Lordship, on the last page, page 42, signature and designation of the inquiry officer. Lordship, serial number 23. Lordship will find the signature there, some Shriman.
Certified copy must bear a signature.
This certified copy has been issued by the Foreigners Tribunal. It looks like, but not sure. We'll get this information, Lordship.
You come to this document, you will find it. See, for example, page 21, the extra copies which have been given to you, the legible copy, page 21. You see, this has in the first page, it has the date.
Yes, it has a date of.
Second page, you will find, again, certified with two copies, that seal is there, page 22.
Inside photos.
It is there, correct?
Yes.
Now you come to page 26. Fine, it is written certified copy of so and so. But the end page of this bunch of certified copy is
No, that, I
at
think
page
29.
44. We tell you why we are saying this is the last, because page 26 you will find, this is page 1, then next page is page 2, 27, then page 3. So it goes and goes on, and then page 14 is page 44. You don't have this authentication of a certificate fee. So I think you should write to the home so that to ensure that certificate copies are put in the manner.
Prescribed manner. This is 10 years back certified copy lordship. 2016,
No, this is the certificate copy now given, 2025, page 22 or 21, whichever.
20,
Page
26.
26. It was issued in 2016. Oh, acha, 16.
Yes,
Okay.
sir. 2016
Okay,
copy.
I wrongly read it. I was reading it as
They are all the certified copies I submitted lordship, they're taken out in the year 2016. Even
this is something we should. You may not write to them again. It's long back.
10 years.
It's not relevant now. I'm sorry, we are dismissing it. We did not observe this 2016. We were reading it as 26. Certified copies were obtained long back, 2016.
Yes, sir.
For then it's 10 years.
An order was passed in 2012 lordship.
You understand? But this I was reading is at 26, so therefore.
But also otherwise, every document, there is no even ambiguity also in the next lordship regarding that.
Maybe, but,
nationality lordship.
10 years is what you call.
That's true, but he's a poor man also, he could not even afford because the other person now helping his daughter.
14 years is too long to interfere with the opinion. Okay, we'll pass orders in the chambers. We have to rise.
Also, once we go to the voter list, there is no ambiguity in the voter list.
Pardon me?
In the voter list since 1960, his father's name and his name appears, and there is no ambiguity in the names also, lordship. So he's a
No, but
pure
if
Indian
it-
citizen. Therefore, some
they-
protection may be given to him.
If it is not contested, then we can't help it.
And there's
Can't
not in the
rewrite-
country now to be protected
We
also.
can't rewrite the procedure. Pass order in the chambers, we dismiss. Okay, online tomorrow.
Upgraded item 32.
Next is the lordship. May I please, your lordship? Lordship, the IAS for rectification of cost title, wherein respondent number 3 and 4, there has been written as Huzai. Lordship, Superintendent of Police Border, it should be Nagaon, lordship. Respondent number 3 and 4.
Order number
3 and 4. In your writ petition, lordship, it's
Three-
written as
3
Huzai,
and 4, it is Hujai. Okay.
but lordship, it's the clerical mistake, it should be Nagaon, lordship. And lordship, in a main petition, lordship has directed us to file some documents, bring some documents into record
for additional affidavit lordship. Because of this error, we could not file the additional affidavit lordship. Because subsequently in the further orders, this mistake will appear.
Your name?
Miss Ailsen lordship.
And Ms. A. Hussain, and talk to the applicant and transfer for the response. It is that in the first title of the writ petition, due to inadvertent error, the Superintendent of Police Border Hojai and the District Commissioner Hojai have been included. Up to have been which force Superintendent of Police Border Gauhati and District Commissioner Gauhati. Accordingly, by filing this interlocutory application, it is made for allowing rectification of the process in respect of the said respondent numbers 3 and 4. Next, having heard the CCC from State and Departmental Counsel, the clear is allowed. Respondent is allowed for substitution of Superintendent of Police Border Hojai in bracket respondent number 3 as Superintendent of Police Border. You can give the chat as per the chat. Next. According to this, interrogative application stands allowed and disposed of. In case you say, in view of in view of the order passed today in IAS, the rectification of the substitution of respondent 3 and 4 has been allowed. The petitioner shall file the amended cost title. And hand it over to the AOJ 50 section for inclusion in the writ petition and consequential collection of the CIS system, of the data in the CIS system. Thereafter, the matter be discussed. Again, in the motion column. Make it 2 working days. 2 working days
We will be given 1 week time, lordship.
for substitution of
No, lordship, for bringing to records the additional affidavit, lordship.
no additional. First, you'll have to amend the cost title.
Oh, yes, sir, lordship.
2 days time, then after.
Highly obliged.
Upgraded item 33.
Please, Your Lordship.
Yes.
My lord, I pray for implement of party as respondent number 7 and 8, my lord. As because, my lord, initially the case was filed in Borpara district, and direction also made against the petitioner to appear Borpara. But subsequently, due to reorganization of district, that village was situated
But
with.
look in your cost title, you have again not implemented, given that 7 and 8.
Yes, my lord.
Look at your cost title.
Yes,
Even in this cost title, you have not made them, you have not named them in the cost title.
cost title, my lord, it is 5 and 6. These are also necessary party, my lord.
But if you want to impeach someone,
My lord, I
Where have you given their description?
page 4, my lord. Paragraph 4, my lord, page 5.
Your prospect is defective. Actually, when you want to impeach someone, you would have to give their names in the first title that you have omitted. Should have given.
7 and 8 लिखी जो 7 and 8 अपना नए देखो
7 and 9 and implement for usage. I prefer implement, my lord.
No, it has to be given.
these are not there नाम नए देखो इंक्रीज कोई तुमने ऐड कोई से माइनस कोई
Yes, in paragraph 4, I have,
That's not the way. You have to give it in the cost title.
in the respondent list
But we allow it. Yes. Well, but Mr. KU understand how to be.
second class first to हमने अपडेट नहीं दिया second में जो ऐड कोई भी नहीं
Has been submitted that due to reorganization of districts and jurisdictional changes, the case of the petitioner is now being dealt with the Superintendent of Police Order Baksa. Therefore, the Act seeks to impede the Superintendent of Police within bracket order of Baksa. And the District Commissioner Baksa was given in paragraph 4 as respondent number 7 and 8. Having heard the learned CC, State and Department of Affairs is allowed for impeding of set to authorities as respondent number 7 and 8. The petitioner shall file an amended costet in the connected writ petition within 2 working days, by handing it over to the KOT section for incorporating it in the writ petition and for consequential completion of the data in the CI system. And these petitions can be allowed and disposed of. And there is a consideration of.
obliged.
Upgraded item 34.
Yes,
34, my lord, I prefer some amendment, my lord. Relating to 5 and 6, my lord, respondent.
okay.
File number 916, the corrected part is at page 6. The SP Borpeta changes to SP Baksa Lordship. And District Commissioner Borpeta changes to District Commissioner Baksa.
No, because this time he has given it in page 4. So in this case, he is more wise.
He has put it twice, Lordship. He's put it in the paragraph also and he's put it in the clause also, Lordship.
previous case, he made a mistake, now he rectified himself and then upgraded himself. By filing this application. Include the application, submitted that there was a typing error in any of respondent numbers 5 and 6. And accordingly, it is prayed that the respondent of 5 was by Superintendent of Police Border, Borpeta, the substituted by Superintendent of Police Border, Paksa. And the respondent 6, that is the Deputy Commissioner, District Commissioner, Borpeta, is now substituted by District Commissioner, Paksa. Having heard the State and Department of the prayer is allowed. Petitioner shall commit the amended constitution to the AOG Act section. It's allowed in disposed of. Then there you say that the count 5 and 6 was that the AOG section within 2 working days. Putting in the petition and for correction of the data in the LCI system. Thereafter, this is the matter. That will be listed in which column now? Motion. I think let me see how. After special matter with respect to the motion column.
Upgraded item 35.
I is there, my lord, that may be listed on like that. The retribution may be listed along with one I, another I is there. Obliged. Lordship, we have filed this IA for substitution of legal heirs of Sarvajan Nasha, who has died. And also, we need to change the cost cycle as one of
Where
our
is the death
cycles
certificate?
expired.
Where is the death certificate? It's,
Death certificate will also is at page number 12, annexure.
This one I can allow it, substitution. Third, Mr.
ZH Bola. ZH Bola.
ZH for us and it to be giving on behalf of the Mr. A.R. Singhal for the applicant on record. Next paragraph. The learned counsel for the applicant, by referring to the death certificate annexed as annexure A to this writ petition, has submitted that the petitioner in the connected writ petition, namely Sabur Jan Mehsa, has died on 15/12/2020. And in this regard, death certificate issued has been issued on 10/2/2021. So, however, the said death certificate, the name of the deceased is written as Chaburjan, CHABURKJAN, Nessa.
Ashish question.
Wife of Sikandar, Sekendar, Sikandar Ali. And accordingly, this interlocutory application for including the applicants as the legal representatives of the deceased submitted that as there are consequences attached to the opinion which is in the challenge in the connected writ petition. The pleading has been necessitated. Having heard the learned CCC state and learned department Gauhati, where making this application now is about. For implementing the applicant numbers 1A to 1K. The substituted verifications in the connected verification. This stands allowed and disposed of. And in the main picture, third so in view of the order passed today in the connected. IS Civil 917 of 2026, by which substitution of the petitioner was allowed, it has been allowed. The applicant shall provide amended copy of the cost title to the ALJ 30 section for the incorporated in the rate petition and for updation of the data in the CS system. And thereafter, the matter will discuss. But okay, this will go for hearing. Rule has already been issued. The district for hearing. Week commencing 25/5/2026. It's time to find amended.
Motion. Item 20 for admission.
Yeah, please. I have to take inspection about Citizenship Amendment Act, my lordship. The petitioners belongs to, I think, my lord, under CA, my lordship. So, one time, give a chance to me, my lordship. I'll take inspection about it.
On the both sides as presented on the prayer made by learned counsel for the petitioner, the matter sent today. List on, give a date after.
After the-
After the
29th April.
Master bless.
Item 22.
Next, my lordship. My lord. Next, my lordship. In this case, Mr. Kepal is supposed to appear, my lord. Mr. Kepal is supposed to appear, my lord, but due to personal difficulty, he is not available today, my lord. Can it be taken day after tomorrow, my lord?
Lordship, not the day after tomorrow, your lordship. It is a very short date. I have other cases instead. For the respondent number 3, your lordship.
It was too much. Yes, yes, doctor. If I have a small mention, Logic, item one, we had done it timely. Mr. Sharma has some personal difficulties not coming today. Can it be fixed for next week, Logic? One Logic. Next week, any day. Logic, after Bihu also, Logic. After Bihu also, Logic. 26th of 26th of April, yes, Lord. Yes, Lord.
Item 9, fixed at 2.
See you.
I think your lordship going to be regularly here. Tomorrow also.
Yes.
I think the report, madam.
There's no reference against,
Yes, no.
send it back. This, the opinion against them
Yes,
has to be interfered
yes, sir.
without prejudice to the
Right of the
State
state, yes,
to
yes. Again,
but Mr. U. Datta, learning counsel for the petitioner and so and so for the respondents. Next, by filing this writ petition under Article 226 of the Constitution of India, the petitioners, namely, give the names, basically, have assumed the opinion dated 25/11/2013, passed by the learned member, which was page 95. In case number 72, IMDT case number 72, which the petitioners, along with Musammat, MUSSWT, Musammat Jarina, JARINA, Jarina Khatun, They are the mother,
Yes,
the mother of the present petitioners were,
as well as their deceased father.
Hmm?
As well as their deceased father was also declared for.
oh, okay, yeah, along with so the projected mother of the petitioners, and what is the name of the father?
Sarol,
Oh, Harul Basa,
Khairul Basa, alias Sarol Basa.
late, and late Sarul, S-A-R-U-L, Basa, B-A-S-A, the projected father of the petitioner, were declared to be foreigners of post 25 to 1971 scheme. Next para. The learned counsel for the petitioners, by referring to the tribunal's records, has submitted that the initial inquiry suspecting that the proceeding was a foreigner, was made against Musammat Jarina Khatun, and accordingly, investigation was carried out against Musammat Jarina Khatun, and the Superintendent of Police within bracket border, Morigao, made reference before the then illegal migrants within bracket determination bracket post tribunal, Morigao, on against Musammat Zarina Khatun alone.
Page 81 is the reference.
However, while registering the proceedings, just have to stop. Thereafter, as the illegal migrants, the bracket determination by tribunals bracket post act 1983 was declared to be ultra vires, and the illegal migrants within bracket determination bracket post tribunals were made dysfunctional by government notification dated 2006 and 5/7/2006. The matters which were pending before the foreigners, before the then illegal migrants determination tribunal were transferred to the foreigners tribunals. And accordingly, FT within bracket C 9 of 2009 was registered before the foreigners tribunal second Morigao, and the proceedings had started against all the petitioners, apart from the projected mother was the against whom the investigation was carried out. Next para. The current standing cost for the FT and water matters has been heard in the matter, and it is seen that on consultation of the on a perusal of the tribunal's records, there is nothing to show in the records that any investigation was carried out on any of the petitioners and that the investigation was only directed in respect of Muhammad Jalina Patul. In this regard, court takes notice of and then in this regard, court takes notice of the reference which is reference dated 28/2001, bearing memo number Roman 3 2-0 within bracket small a bracket close oblique 228/2001 by the Superintendent of Police Border Morigaon within bracket exhibit 4 by which reference was forwarded by which inquiry was started against Muhammad Jalina Khatun. The form of inquiry, which is exhibited as Exhibit 1, Exhibit 2, Exhibit 1 and Exhibit 2, where it's found to be directed only against Muhammad Jalina Khatun. And the reference by the Superintendent of Police in bracket order was Morigaon in respect of FT case number 228/2001, dated 28/3/2001, was made before the illegal migrants within bracket determination by the tribunal only against Muhammad Jalina Khatun. The learned standing of the LT and bottom matters could not find any material. The fabulous records contrary to the above. Next, accordingly, as there was no valid reference against the present petitioners, namely so and so, the court is of the considered opinion that the impugned opinion dated 25/11/2013, passed by so and so, page 95, is not sustainable in respect of the present petitioners, namely so and so, page 3. Against whom no reference was made. Accordingly, the said impugned opinion dated 25/11/2013 is set aside in respect of the present petitioners, namely so and so, without affecting the opinion against Muhammad Jalina Khatun, against whom the inquiry and the reference was made. Next paragraph. However, before parting with the records, it is provided that this order shall not come in the way of the competent authorities, including the Superintendent of Police Border Morigaon, to make an inquiry against the present petitioners. If any doubt exists of they being not Indians but foreigners. this resistance allowed to the extent as indicated above. This proportion, you know, this next paragraph. The registry shall send back the tribunal's records back to the learned foreigners tribunal second Nurigaon, along with a copy of this order to be made a part of records for by the said learned tribunal for future reference. Next, in the meantime, the no, not in the learned standing for the 18 border matters is also requested to send a downloaded copy of this order to the authorities in the Home and Political Union bracket B bracket was department. Government oversight.
So it is. So far as lots of declaration in respect of my father, I also challenge that on the same ground.
Here on this.
Yes. Because last line, paragraph 14, in my opinion, of Zarina Khatun, daughter of so-and-so, her husband, let's Saral Basa. He was also declared.
Petitioners as well as which page?
Page 98, Lordship will find paragraph 14 of the opinion.
As well as
Second line.
Sarul Basa, SARUL Basa. He is one of the this is father of the present petitioners. This so does this.
I would like to.
Item 24.
I have to.
Lordship.
Yes.
Lordship, this is an appeal filed by the state lordship against the judgment and order dated 29/2024, passed in series of petitions also. Several petitions were there. And Lordship, the facts of the matter relates to there was a notification, Lordship, issued by the state of Assam. Lordship will find it page 53.
Yes.
Lordship, I am furnishing legible copies, Lordship. Same, Lordship, it starts from page 53. It was notified on 22nd of January. This notification date dated 20th January 2021. If Lordship reads the first paragraph there in Lordship, the Governor of Assam is pleased to order on the acquisition through direct purchase by way of negotiated settlement for improvement and upgradation of state highways and major district roads under Assam Mala program and externally aided projects as enunciated in the enclosed document in Annexure 1. It will come into force with effect from the date of publication in the Assam Gazette and will remain in operation till such time as the state government may consider fit and proper. The government of us also reserves the right to make any amendment to the policy from time to time. Next page, Lordship. In annex, this is Annexure 1, Lordship. The procedure has been laid down there. Land acquisition through direct purchase by way of negotiated settlement for improvement and upgradation of state highways and major district roads under the Assam Mala program and the externally aided project. 1. Government of Assam has initiated the flagship program Assam Mala for improvement and widening of state highways and major district roads
It would be a large and prestigious long-term road infrastructure development program, which in addition to the state-funded work, would also include several externally aided projects EAP under its umbrella. The works under Assam Mala would involve big highway contracts with substantial land acquisition. The readiness criteria for EAPs require completion of 50% of the land acquisition for a project before loan negotiation. Ministry of Road Transport and Highways stipulates 90% land availability before starting of the work. The right to fair compensation and transparency in land acquisition, rehabilitation and resettlement Act 2013, enacted by the Government of India with effect from 1st January 2013, superseded all previous land acquisition acts and rules in India. It includes provision for rehabilitation and resettlement of project affected families and persons in addition to cost acquiring land. The state of Assam made the Assam RFCTLARR rules 2015 on the provisions of the RFCTLARR Act 2013 with a number of sequential compulsory process, involvement of number of bodies, as well as statutory waiting time between different processes. Acquisition of land as per the general procedure laid down in the said Act and rules require a very long time from notification to possession of land. Assam Mala, being a flagship program of Government of Assam, calls for expeditious acquisition of land for speedy implementation of the program. Section 46(1) of the RFCTLARR Act considered for direct purchase of land for the program. Government of Assam has adopted land acquisition through direct purchase by way of negotiated settlement for improving the upgradation of state highways and major district roads under Assam Mala program and externally aided projects. The important steps and features of the direct purchase schemes are as follows. From 4.1 Lordship, this is the procedure. 4.2 Lordship, a district level land purchase committee under chairmanship of concerned DC is to be constituted for direct purchase of land as well as fixation of market value, etc. The DLLPC will be constituted with the following concerned persons. This is the list, Lordship. 4.3, Step 3. Concerned Revenue Circle Officer, concerned Executive Engineer of PWD Building, along with representative of requiring department will conduct joint inspection of the requisite land. The area of the land and immovable properties attached on it will be measured and met. 4. General notice shall be issued by the district level land purchase committee inviting the attention of the landowners regarding purchase of the land. 5. The owners of the land who may agree to sell the land may be identified and a list may be prepared after ascertaining the actual owner of the land. 6. The list may be published inviting objections, if any, regarding interest of ownership of the land, etc. There may be 1 month of waiting period for receiving objection from the landowners, if any. 7. The LLPC will prepare the valuation of the land and assets. The requisitioning agency may also define a few typical immovable assets of different categories and fix the guidance price through appropriate authority. The price of the assets attached to be the land may be calculated on pro rata basis on typical immovable assets mentioned above. 8. The valuation of the land assets, if any, thereon. The particulars of the land, name of owners, etc., shall be processed. 4.9, this is important. The direct purchase shall be 25% higher on the compensation calculated as per provisions of section 26 to 30 of Schedule 1 of RFCTLARR Act 2013 with multiplier of market rate of land defined through the Assam Land Acquisition Notification number so and so dated 22nd December 2014 in compliance with section 26 and serial number 2 of the schedule of the RFCTLARR Act 2013. The RNR benefit will be deemed to be included in it. RNR is the rehabilitation and resettlement. Step 10, on completion of the statutory waiting period specified in step 6, the DLLPC will inform the respective landowners who are interested or not raising any objection for negotiation. 11, pre-informed negotiations with the respective landowners will be carried out by the DLLPC. DLLPC. 12, the settlement reached in the negotiation shall be recorded as agreement through Form B and Form C of landowners, and for interested persons other than landowners, if any respectively. An undertaking may be signed by the landowners declaring that they will not claim for payment of higher compensation, if any, in any court of law or any other forum, and shall abide by the sale agreement finalized by the DLLPC. The landowners and other interested persons have to provide their electronic transfer details through electronic transfer mode. 13, the Deputy Commissioner District Collector may requisition necessary funds from the requisitioning authorities. 14, the Deputy Commissioner District Collector shall make an award according to the terms of such agreement by DLLPC. The possession of the land is taken through paying the negotiated price directly to the landowners or interested persons other than the landowners, if any, through electronic transfer to their respective bank accounts. 4.15, I'm skipping Lordship. 4.17 is important. In the event of any owner refusing to sell the land, or any of the owners has objected or not interested with the direct purchase through negotiation, the respective land may be acquired through land acquisition process of Assam Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Rules 2015. So basically, this is the procedure, Lordship. If Lordship comes to paragraph clause 6, Lordship, the direct purchase method will be all encompassing, all inclusive of all compensation and RNR benefits as specified in 2nd and 3rd schedule of RFCTLA RR Act 2013, or in RNR benefits of multilateral development banks of title holders. The price of land shall be fixed based on negotiations and mutual consent. Hence, no separate rehabilitation and resettlement benefits shall be payable to the landowners. So basically, this was the scheme, Lordship. This was formulated in the year 2021, basically for the purpose of expediting the process of land acquisition without any application of the Land Acquisition Act of 2013. Now, Lordship will notice this notification is not under challenge insofar as the present petition is concerned. It is not under challenge. So, on the basis of this scheme, Lordship, the land of the present petitioners were negotiated and decided to acquire, Lordship, if Lordship comes to page 44 of the petition of the appeal, Lordship. Page 44, this is Annexure A, Lordship, of the writ petition. Serial numbers are there, first column, Lordship, 47. 47, he is Punaratta, he is petitioner number 9, Lordship. Next is 48, Lordship, he is petitioner number 8. 55, Lordship, he is petitioner number 1. All the petitioners are here. Serial number 47, Lordship, petitioner number 9. 48 is petitioner number 8. 49 again petitioner number 3. 50 is petitioner number 9.
No, petitioner number 9 is 47, you said.
Two lots were there, Lordship. Both 47 and 49, 50 both. Two plots.
50 and P9.
47 and 50, both P9. Then Lordship, 53 is petitioner number 3. 55 is petitioner number 1. Next by Lordship 57, his petitioner number 4. 58 is petitioner number 10. 59 Lordship again petitioner number 4. And 64 is petitioner number 6. In short, Lordship, on the basis of the negotiation, by following this scheme, Lordship, a particular amount was arrived at, and accordingly 50% of the same has already been paid to the landowners, Lordship. Thereafter, Lordship, if Lordship comes to my affidavit, Lordship, and that start from page 71. I am at page 72, paragraph 3. Page 72, paragraph 3. That with regard to the statements made in paragraph 9 of the petition, I say that based on public complaint, petition submitted by Sri Mintura's Kaman and others, a case was registered at Dhemaji Police Station by Dhemaji PS case number 14923 under section so and so IPC and Vigilance PS case number so and so of Chief Minister's Special Vigilance and investigation process is going on. This office has not received any further amount towards compensation from the government. That with regard to the statements made in paragraph 11 of the writ petition, I say that a criminal case was registered in Dhemaji Police Station by case number Dhemaji PS case number so and so, wherein investigation is going on. The matter is also under investigation under CM Vigilance by delegation number so and so of Chief Minister's Vigilance. Yes, next paragraph, Lordship, paragraph 5. That with regard to the statements made in paragraph 12 of the petition, I say that the project improvement and upgradation of road from Dhokwakhana to Telijan under Assam Mala was acquired by land acquisition through direct purchase by way of negotiated settlement for improvement and upgradation of state highways and major district roads under Assam Mala program. An externally aided project EAPs as notified in the Assam Gazette dated 28 January 2021. Moreover, after receiving the allegation from Public Accounts Committee based on public complaint petition of Sri Mintura's Kaman and others against alleged anomalies in assessing compensation of land acquired at village Pathaliyal under Dhemaji Revenue Circle, assessment committee was formed and reassessment was carried out by them when it was found that there was a huge amount of difference between the earlier assessment and the new assessment. Therefore, the matter was forwarded to the Principal Secretary to the Government of Assam Revenue and Disaster Management Department for
Assessment,
reassessment.
and we understand,
Yes.
but you see, if you are a bench before us, I may be very miserly and my sister may be very, liberal. And she makes her assessment of 100 rupees. I make an assessment of 50 rupees.
No.
No, just
Yes.
giving an example. But when you have already entered into an agreement to price,
Lordship.
how can there be a second reassessment?
Yes, Lordship.
We can hold.
I'm coming to that point. Lordship, so far as assessment is concerned, that is not regarding the price of the land, value of the land or of the property, Lordship. This is assessment as regard the area of the houses, Lordship. Suppose there is a house, Lordship, which is area, having the area of 217 square feet. In the assessment, Lordship, it has been shown as 272 square feet. That was found subsequently, Lordship. Lordship, I am basically on the point of fraud,
But in
Lordship.
the affidavit, you don't say that. You have not stated that the earlier assessment was fraudulent. You don't arrest your people who have done the, what do you call the fraudulent assessment.
Yes,
Have you arrested any one of them?
yes, Lordship.
What is that?
Several engineers have been arrested, Lordship. They are facing criminal proceeding, Lordship. Their departmental proceedings are also against them.
First,
Even the petitioners, Lordship, these petitioners, charge sheet had been filed against them, Lordship.
petitioners, you, for the time being, you keep it aside. Any engineers or other officers who were there in the fraudulent?
Yes,
assessment?
Lordship, yes,
Where is the-
they are facing Lordship. They are facing Lordship, probably in this petition,
and
Lordship.
where is the finding that the plinth area and other things, assets are not there?
That has been recorded, Lordship. If Lordship comes to page 91 of the judgment, Lordship, impugned judgment, Lordship.
91.
Yes, Lordship. It starts from paragraph 29 in the page 90, Lordship. It starts from page, paragraph 29, Lordship, page 90, Lordship. May I read, Lordship?
We are
Now-
doing it, we have to wait.
Yes, Lordship. Next page, Lordship, small Roman 3, Lordship. Lordship, may kindly see the names there. It is from the report itself, Lordship. One Nila Kos is there, Sandra Datta there, Thaneswar Datta there. If Lordship comes to small Roman 5, Lordship, Roman 4 and Roman 5, Jayanta Datta, he is one of the petitioner. Roman 5, Pankaj and petitioner, Amulya Soikia petitioner, Biren Soikia petitioner. Lordship will, most importantly, Lordship will take note of paragraph 30 of the judgment. Next line, Lordship. However, interestingly, in the aforesaid assessment, names of the petitioners are not there. Just one line above the petitioners are there, Lordship.
What's the names in the red petition?
Number 1 is Pankaj Mohan Yen, Lordship.
Again,
He is petitioner number 1. Amulya Soikia is 3, Lordship. Biren Soikia is 4, Lordship. All the names has not been mentioned there, Lordship. The measurement of other affected persons like Pankaj Mohan Yen, Amulya Soikia, Biren Soikia, etc. also was found exaggerated and erroneous. So in the very next line, Lordship, Honorable Learned Single Judge said their names were not there.
then Mr. Bhattacharya, you're opposing this.
Lordship, there are two things, Your Lordship. Your Lordship. Your Lordship will kindly see that this kind of statement, Your Lordship, that measurement of other affected persons like so and so, so and so, what there have to be some kind of materials to show that what kind of, Your Lordship, anomalies is there in respect of that. That is one, Your Lordship. Secondly, Your Lordship, we are not about that, Your Lordship. What is Your Lordship? Your Lordship has seen this, Your Lordship. The office memorandum, Your Lordship. This is, Your Lordship, this has a source of power in section 46 of the plan acquisition of 2013. Your Lordship, ultimately, this particular office memorandum has been issued by exercising power under section 46, and it is, Your Lordship has gone through. It is a private settlement negotiation, Your Lordship, negotiated settlement. Only because that is why, Your Lordship, that is what has been held by the Honorable Court, Your Lordship, Honorable Single Judge, Your Lordship, that, Your Lordship, once it is a private negotiations entered into, you pay fine. Where is the power to reassess it? Number one.
That may not be correct.
No, Your Lordship, let me submit, Your Lordship. Secondly, Your Lordship,
Let me
Lordship,
tell you a simple thing.
Lordship,
Somebody engages you, I'm giving a very horrible example,
Lordship.
excuse me for that.
Lordship,
Somebody has engaged you, paid you X amount of money
Lordship,
to file a writ petition.
Lordship,
It's a private settlement.
Lordship,
Now you don't file a writ petition.
Lordship.
Can somebody not make a complaint against you that please recover the money, though it was a settlement? That
No.
I would give him X money, X amount of money, but no writ petition was filed.
That's your lordship, that is between two individuals, your lordship. Now here it is a state and my property is taken, your lordship.
No, property is taken.
Your lordship.
Means the property must be an, what you call an intrinsic property having some, something in it.
Your lordship will kindly see the assessment they have done behind our back. No notice has been issued to us at any point of time. Now, your lordship, without assessing, without giving us any opportunity, they arrived at a certain finding. Based on that finding, they said that we will not pay you the 50%.
You can have a joint measurement because you see, it's very simple. Somebody sells your property.
Lordship.
You go and inspect that property, and in that property you find that there is a wall clock there.
Lordship.
Correct.
Lordship.
Now, when he hands over you the property, that wall clock is missing.
Lordship will kindly see, so far as this is concerned, the example your lordship has given, your lordship, I don't have anything on that, your lordship. Absolutely correct, what has fallen from your lordship's law. But this is a case, your lordship, a constitutional guaranteed right, a procedure established by law, only your lordship property can be acquired. Now, ultimately, reassessment means what? Reassessment means review of the award. They have passed an award under section 46. And under 2013 Act, there is no power of review, and Supreme Court has said that power of review, so far as land acquisition is concerned, is not there. Though when power of review is not there, they cannot reassess it. Reassessment means, your lordship, award will have to be reviewed. Your lordship will kindly see this judgment, your lordship, of the Honorable Apex Court, your lordship. 2019 9 SSC 416.
Section 6 of the General Process Act, right to do and right to undo is inherent.
No, your lordship, when this Apex Court has categorically held that power of review when it is not there. May I read, your lordship, one paragraph from your lordship? I will hand it over here. A bare reading of the section 13A of 1896 Act make it clear that same is not a provision for review of the award, but only for correction of clerical or arithmetical mistakes in the award. It is further provided that subsection 1 of section 13A that the said correction can be made at any time, but not later than 6 months from the date of award. In the present case, land acquisition collector has actually not made any correction of clerical or arithmetical mistake, but has in fact reviewed the award dated 1/10/2003 by its review award dated number 16/2020 0304 dated 14/7/2004, which was clearly passed beyond such period of 6 months. In my considered view, the review award could not have been passed under section 13A of the Act, which is meant only for correction of any clerical or arithmetical mistake. There is no other provision in the Act under which the said order dated 47/2004 could have been passed, your lordship. It is a subtle law that the power of review can be exercised only when the statute provides for the same. In the absence of any such provision in the statute concerned, such power of review cannot be exercised by the authority concerned. The court in Kala Bharati Advertising and so has said so. Now, your lordship has given me an example. If I am not given, I was engaged by making certain payments and I have not filed any petition, then there is what will be the option available to them? So they will file suit against me, your lordship. Even if today they feel that any payment is made wrongly to me, they will have to approach the competent civil court, your lordship, for review, and where I will get the opportunity to rebut their case. Now, without giving the opportunity, your lordship, they have decided to review the award, they have reassessed the compensation, and I am never been taken into confidence while passing that order, your lordship, that decision. How can it be, your lordship? And your lordship has seen that except so far as the rest of the petitioners are concerned, there is no mention about that. And in fact, if they have decided not to give us the payment we have agreed for, we would not have entered into any agreement with them. then they would have to follow the land acquisition proceeding, your lordship. Proceeding under Land Acquisition Act, your lordship, that they will have to follow. And in that case, your lordship, I would have got, your lordship, opportunity even to go to the reference court. Now, when everything has been closed for me, they decided on their own that this will be the award. Then again, they decided that you will reassess it without giving us any opportunity, without having any power. How can it be, your lordship?
Examine it, but
And 50% of the compensation has been paid, your lordship. My land is vested with them now, your lordship, after payment of compensation, your lordship. Now, without having power, your lordship, how can they assess it? And without giving us any opportunity, how can they pass, your lordship, fix a compensation, your lordship? That cannot be. And on the other hand, your lordship,
the houses and structures, they are there or demolished?
no, your lordship, some of them has been demolished.
But the land
Half
is
of-
yet to be handed over. Lordship.
Where
We
is the
have not
question of
taken
it? Best
possession.
with them.
In fact, Lordship, we have changed the alignment of the road. Now we are not using their land also. That is a
Once-
different issue, Lordship.
Once
That is a different
payment
issue.
is made, award is given, that land vests with them, your lordship.
Lordship,
I have,
Lordship, the issue will
No,
be,
just a moment, let him complete.
yes.
Let
Lord.
him complete.
and in fact, in IA, they have said that for delay condonation, that they are, so far as the interest part is concerned, they are more concerned about that interest part. I am ready to forego that, your lordship. Interest I don't want. I only want my compensation, your lordship.
Lordship, in fact, what I prayed before learned single judge, Lordship, I'm not saying that till that moment, Lordship, I was not saying that I am not going to pay you the 50% amount. My only prayer before the learned single judge was, let us wait for till the inquiry is complete. Once it is established in their favor, Lordship, we will definitely pay them the 50%, Lordship. There was no question there. But my basic submission will be, Lordship, the scheme is not under challenge. That issue you have not raised before the learned single judge. So scheme is still holding the field, Lordship, and the price was negotiated only on the basis of the formula given in the scheme itself. Only difficulty was our officers, in collusion with the petitioner's, Lordship, wrongly shown the assessment figures, manipulated the figures, Lordship, and on the basis of those figures, Lordship, a higher amount was fixed. That is my only grievance. And that is why, Lordship, my basic submission will be, Lordship, it was, those figures were manipulated fraudulently, Lordship. That is the only issue. Whether I have a power to review or reassess, have or not, Lordship, that is a different issue. But fraud, vitiates everything. That is my basic case, Lordship.
In fact, your lordship, the inquiry report based on which this reassessment is done, your lordship, has categorically stated, your lordship, now that petitioners have no role in it, your lordship. That is, your lordship,
For till the next date,
lordship,
this operation would be stayed. Obliged, Lord. You agree to a date of hearing
lordship.
after behold. Heard. Mr. P. Nayak, learned petitioner advocate general, assisted by P. Baba and Public then State Council, as well as brought up the audit. The judgment on order dated 20 September 2024, passed by the Honorable Single Judge in WPC 6760 of 2023, and other linked cases have assailed the said judgment and order only in respect of WPC 6760 of 2023,
Next, the court is inclined, having heard the counsel to the respondents, respondent numbers 1 to 10. Who is appearing for 11, 12, and 13? 11, 12, 13, 12. Respondent.
Government.
Mr. Garika was here.
Revenue Department. Government approval account.
Revenue, who will appear?
Rajiv Borpujari, R. Borpujari. For DC Lordship, government will appear. Puna se.
They are not here. Can we record their presence?
Government of particular.
Can we record their presence?
Lordship, they will be informed by.
Start out to say, for the Revenue Department. The former respondent Metavel. And the HK Azarika, the government advocate appearing for respondent. Former respondent Metavel. Next. You can not comma issue. The court is inclined to admit this appeal, inter-court appeal for hearing. Next. Affidavit opposition from a penny, he filed prior to the 2 days prior to the next date of listing. Next list from
On, if possible, Lordship, on 14th Lordship, May.
14th of
May.
May, your lordship, it will be. May, your lordship. Since your lordship has passed an interim order, your lordship.
we fix it
By
on
then.
28th of April,
Lordship,
28th, 4, 2026.
28th.
Then the extra copies you have got.
Yes, your lordship, but your lordship, these annexers are not legible, that's the only problem, your lordship.
The
Completely illegible, your lordship.
the extra copies of the copies of the appeal eligible just be provided to the learner. Asking for the respondent numbers 1 to 10 to the what is this? Do that just by getting on first. And the IA. IA is
Number 1. I.
right. 530. But Mr. P. Nayak on the same, third 20. Next. By filing this interrogatory application from the applicants who are the aforementioned connected with appeal, saying for stay of the operation of the implement judgment and order dated 29/20, common judgment and order dated 29/2024 in respect of WPC 6760 of 2023 only. Next. Well, the learned counsel for the additional advocate general has submitted that in this case, though there was an agreement for paying land acquisition compensation in terms of this three stuff. In terms of notification dated 20 January 2021 in respect of this. But subsequently it was found that the assessment was fraudulent and not based on the actual measurement of structures which were standing on the acquired land. So the land sought to be purchased through direct purchase. Next one. The Counsel for the respondent numbers 1 to 10 has proposed the prayer for stay on the ground that the said notification dated 20 January 2021 has been made in exercise of power under section 46 of the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act, 2013, which does not have the power for review. Accordingly, it is submitted that the reassessment that was made, which is the basis of reducing the compensation for direct purchase of land by negotiated settlement, was done behind the back of the respondents, just to deny them the fair compensation, the payment for the public payment for the land, which according to me is impermissible under the scheme. It is further submitted that as the respondent numbers 1 to 10 have already been paid 50% of the purchase compensation, the entire property seemed to have been vested with the state, and therefore the negotiation of purchase or made cannot be resided by the state.
Lord, sir.
Either as it may, as the connected appeal has been admitted for hearing. Next date of listing, the court is inclined to stay the operation of the impugned judgment and order dated only in respect of WPC 6760 of 2023, without affecting the enforcement in respect of the other connected cases. Next. You should notice on this interrogatory application, which is made returnable on Wednesday. Next, list. Objection, if any, be filed prior to next date of this term, same day.
Lord,
Issuing notice here of
Lord. Deeply obliged.
Item 25.
Mr. Kohli, will have to rise for the single bench.
Yes, I believe leadership has a bench at 3:15. In this matter, Lordship, we've of course, after the last notice, item 30, we filed that affidavit, but we have to still file a detailed affidavit in opposition. So maybe you can fix a date and give us that time and we can come in. Because there are 2-3 things, if I may just mention only, I'll be there before late.
Staying back tomorrow? No?
I am,
Fix it tomorrow?
if you wish. But I have to still file my affidavit in opposition. No, I'm in any case tomorrow, you know, for the other matter. So otherwise, Lordship, will just give us time to file an affidavit in opposition.
How much time?
At least 2 weeks, Lordship. You understand elections are on. Maybe 3 might be better, Lordship.
Yes. 2 weeks, your lordship.
No, I think 3, Lordship. I foresee everybody is going to be busy till the election.
It is. It's true.
It's true, Lordship. I mean, then we'll be coming here and saying couldn't do it. 3 weeks is fair.
Nothing is happening then before.
Up to 7th, Lordship understands everything up to 9th, technically.
11th, no.
Yes.
Before 11th.
And Lordship, give us some date later and give us 3 weeks, Lordship. End of April. In fact, Lordship, our SLP, which is on the judgment, is before the Honorable Supreme Court. The next date is the 8th. And then BHO and
This is item number?
this is 30.
13.
30.
For contempt petition.
So maybe after BHO, Lordship.
Then I would kindly pray for the 22nd, your lordship. 22nd of April, if my senior has.
Or 29th. Bar Council election on 22nd, 29th.
Oh, bar council election.
29th, Lordship.
Mr. Chaudhary was here. We record his name,
Lordship.
but Mr. K. N. Chaudhary, Learned Senior Counsel, assisted by Mr.
T. Kashyap, Your Majesty.
T. Kashyap, Learned Counsel to the petitioner. To Mr. N. Kohli, Learned Senior Counsel. Assisted by, just give your names.
So we'll give the names. Even Mr. Dipankar Nath and his colleagues are there. My colleagues are there. We'll write it just.
Appeared for, you're appearing for both. For appearing for the respondent. Submit that going to the ensuing elections. He requires some more, he requires some time to file the affidavit in opposition in the matter. In view of the grounds assigned from the matters to sit on today. Personal appearance of the respondents having not been exempted from its take notice that the affidavit will be filed at least 2 days prior to the next date of the speech. List on 29/4/2026.
And physical appearance is exempted. I thought Lordship said that.
So he said that it is not exempted.
Not exempted. Being exempted, Lordship, till the next date.
You have your,
I will, of course, I will.
pray for their exemption.
I will. In fact, tomorrow I'll be assisting Lordship on the whole gamut of it. So all of these arguments will be common. But Lordship may still get this. It's election time already. Everybody's a hassle, not much. Only for the next date.
We'll consider it, make an oral prayer.
I'm making an oral play now.
No, that is,
For 29.
no, that is, you see, the reason is, that's why we have made that special mention. Otherwise, in contempt cases, we still find that for years together, the affidavits are not being.
So actually, Lordship, in fairness, if I may also just a moment I'll take for Lordship and Ladyship's consideration. And I've carried all the law for tomorrow, about 5 judgments. Lordship, it's very interesting. I am also studying the jurisdiction in detail. The contempt jurisdiction is a rare jurisdiction within which it has to be beyond reasonable doubt with a finding of contempt first, before which there has to be a notice for contempt. So a reply, then after the reply satisfaction, then a finding of contempt notice, then Lordship, the contempt, then the purging comes. So I'll of course assist Lordship tomorrow, but I leave it to Lordship's consideration. That's why I was saying only for the next day.
Recent,
And on the, you will have the reply because we only have to draft it.
no. The recent trend of orders from the court were from your.
13. Actually, Lordship, on a very light note, today I found a judgment which is also 3-judge, and that we have been researching on this.
It's okay, good.
So Lordship is becoming an interesting area of jurisdiction.
We'll see that.
Of course, Lordship, we all are here to assist.